All right, we're now calling 25 CR 225, the state of Texas versus Leon Damon Davis. That's you,
Yes.
Mr. Davis, with your attorney, Ms. Minaldi, and the state's prosecutors here. You are charged in this case with evading arrest or detention, and it is a state jail felony. You have paragraph 2, which shows at least four evading arrest or detention convictions. Thus, evading arrest, anytime you commit evading arrest, it becomes a state jail felony automatically. You are looking at no less than 180 days up to 2 years in the state jail, and the fine up to $10,000 can be assessed. Do you understand?
Yeah.
This last one was here in this court, right? In 2022, this last conviction?
That's what I have, Judge, from August of 2022. That one looks like it was a 3rd-degree felony because it was with a vehicle.
Yeah. As you know, you are not eligible for probation here in front of a jury. You understand that?
Yes.
Okay. What was the offer on this?
A year state jail, Judge.
Ma'am?
A year state jail.
Okay. So that's when can we get this tried? Because that's off the table, right? You don't want that. You've decided not to do that, right?
The enhancement, I didn't get the enhancement. I thought you got to have like 3 evadings detention.
You got 3 evadings.
One in the motor vehicle.
You got them all with the motor vehicle.
Motor vehicle. I had one, and I just had one, and I had one.
You got 2. I'm sorry, you got 2 with motor vehicles.
Yeah, and I thought you had to have like it supposed to be 3
No,
evadings.
2. No, 2 gets you. Yep, that's the magic number. When you got 2 that priors and something, you kind of get stuck from here on. That's why it's a good idea not to do this, because it's automatic. It's like people who commit thefts. If they have 2 or more thefts, if they steal a pack of gun, it's a gum, which is what, 50 cents? It's a felony from here on the rest of their life. Then it's similar to evading arrest. The law's treating it the same way. What do you want to do?
They want to go travel. Yeah.
Nobody likes that. I know. But you're looking at up to 2 years. You understand that?
Yeah.
And Judge, I've discussed his options with him. I've reviewed the media with him. We're just at an impasse in terms of discussions.
You've got almost 100 days credit on.
That's not.
Oh, that's not yours.
No, but I can look at it real quick, Judge, and see what he's got.
You know how much credit you had, but we're going to figure it out for you so that it's working. It's accurate the way you think it is. It would have been January 11th, right? So
That's correct, Judge.
You've been in custody since January 11th?
That's
Yeah.
Go ahead, Jim. June.
He has 113 days credit.
How can you do that? Have you been in constant or custody since January 11th when you were arrested? Oh, okay, that's it. That's why.
At least on accusation, Judge, and then
Rearrested?
rearrested. So actually,
June.
right.
In June.
He's been in custody since June of 23rd of this year. Looks like he was in custody for 7 days before his accusation. So 113 plus 7.
Okay.
So he's got.
All right.
20.
So where are we on this again? I think he's figuring out where he stands. Everybody's here. The prosecutor's here, the defense attorney, you. What are we going to do? You got an offer of 1 year? Is that what it is?
That's correct, Judge.
And
And
you've
we've
talked to
tried
him about
yeah, and we've tried negotiations, and that's
What?
the hard offer. And I've
Okay.
spoken with him about what.
He understands he can get credit for good time or being good
Yes,
behavior, and what's this is a quarter, not a half, right? He's looking at parole in a fourth, 25%.
I think
It's not an aggravated offense.
right, but I think state jail just calculates a little bit differently.
Yeah.
I don't think it's a 4th. I think.
Yeah, everybody knows what it is, but I'm not. I'm not
But
clear
I mean,
about
I've been through all of his media with him. I have had discussions with
Okay.
him, and anytime that I am attempting to advise legally, we come to an impasse.
Okay, all right, it's his choice.
Continue.
You know, you're looking at 2 years and, okay, and you're not eligible for probation here, so this is your choice. Okay. That's what you want. Set it for
Yeah,
trial.
good.
Sir?
Yes. Yeah, good.
All right. I want to get this as soon as possible. I don't want him just sitting around in jail. Let's get this done one way or the other. Okay.
Understanding yesterday that he's requesting that I be released. I don't know if I'm fine to stay on if that's what you decide, but he has expressed to me that
He's a fine lawyer. He wins cases, but you can hire anybody you want, but you're not able to hire somebody, are you? Well, you get a competent lawyer and she's competent. That's who you get. Do you want to continue to represent him?
It's his decision, Judge.
No, it's not. No, he can go hire anybody he wants, but the taxpayers' money is controlled by me and he gets a competent attorney, which you are. But there are other competent attorneys too, but what do you want? You've talked to him. You think it would be in the best interest of justice to replace him with somebody else?
I think so because
Then
we
it's,
do not have conversations with each other.
Then that's done. You don't know who you're going to get, but it'll be somebody who's competent and they'll represent you. There aren't any deals. Let's get this to trial as soon as possible. The next person on the list, get him represent and let's move forward. Thank you. I've got John Dixon.
Yes, Judge. He also wants his case set for trial.
Yeah, him out. What's the offer on this?
Half of 10.
Look at it and see what.
It's going to end up being a cap of 20 here in a minute.
Yes.
All right, come on up. 24 CR 2417. You were John Dixon
That's it.
and you were charged with a second-degree felony of aggravated assault with a deadly weapon. If convicted, it carries with it up to 20 years in prison and also parole if convicted and sentenced to imprisonment. You will not be paroled until you have served 1/2 of your sentence. Do you understand? Due to the deadly weapon allegation here. What are we going to do? Yeah, Miss Minaldi is your attorney.
He was just to set his face for trial.
Okay, is he eligible for probation?
He is, Judge.
Oh, yes, is he?
He's eligible for potentially deferred from you if we would have proceeded with the cap of 10, but he's also eligible for straight probation from a jury.
Hmm.
He doesn't have any prior criminal history.
The victim in this case, y'all talk to him, I guess, and he's wants to move forward. Sometimes that doesn't happen, and that's why I don't want this time is so valuable. I don't want. Sometimes people do things and they don't help. But y'all are ready, willing and able with the okay. Then it'll be set for trial, and this one looks. We can try it very quickly. Let's move this fast. Okay, you're going to represent him?
Yes, Judge.
Okay, good deal. Thank you. That's all. We'll set it for trial. Devontae Huff?
Judge, can we reset him to an interview hearing docket, please? That was Ms. Staub's case. I have not had an opportunity to reach out.
Bring him out. We're going to do the MTRP hearing. Give him what he needs to know about so we don't wait. We can make a decision here, but I don't want to start over in 2 or 3 weeks. I'd rather pick up where we are so he knows this delay stuff is just killing us on back in the house and the jail. He's got 2 cases,
He
right?
is, Judge.
Are they both MTLP?
They are.
Oh, yeah. Okay. You're Mr. Huff?
Yes, ma'am.
Got you on 2 cases here, sir. 24 CR 155, 24 CR 169. Who's on this?
It was Ms. Staub. I don't think another prosecutor has been.
Looks like me, Jeff.
Okay. Good for you.
I'll be missed out since she shot me.
Each of these cases are motions to revoke unadjudicated probation. You're charged with state jail felonies of criminal mischief. It looks like you were placed on probation for up to 5 years. On December 2nd, and he's already pleaded true.
Yes, we were here once before, Judge, and he was reinstated because there was a significant amount of restitution involved in the cases.
Switched it up.
And now we're back here again.
They locked me up for trespassing one. That's why I'm in jail. I went here for a motion to revoke. They locked me up for
Do
trespassing.
y'all need to amend this motion?
I don't know, Judge. I have not looked at it.
It does need to be amended, Judge. There has not been a first.
Okay, so
amendment filed.
there's a substantive offense that's come along, allegedly.
There's subsequent allegations. I'm not sure if it's a substantive offense, but
But we put him on probation.
in December of 2024,
I'm talking about this allegation true in June. What did I find then? What was my resolvement on this?
you reinstated his probation.
Okay, that's done. What happened subsequent to that?
I don't know. I don't have a new motion to revoke probation filed.
He failed to report, Your Honor. He hasn't reported since continued on probation.
Okay,
It's my
Oh,
understanding.
yeah, I have
he's
my-
absconded.
you're interrupting.
Yes, sir.
Yeah.
But I'm a lawyer too.
Is that just a smart aleck comment
No, I
or
stopped.
just
No, sir.
you're gonna step over me
No, sir.
all the time, the whole time?
No, sir.
Shh.
Yes,
You're
sir.
gonna get a chance to speak, but the lady has to put down everything as the court reporter, and when two people are speaking, she can't do it. That means somebody gets in trouble. All right. Okay, so the motion sounds like another motion to revoke probation needs to be filed.
And it seems like I have some motions that I need to file as well, Judge.
All right, then
Seems like.
can y'all do that in 2 weeks,
Yes, sir.
everybody? So this man knows what direction he's gonna be heading in?
Yes, sir.
All right,
Please.
all right, that's what we're gonna do. See you back in 2 weeks, sir.
Yeah, thank you.
Okay, here goes. McCarrick Kirkwood.
He's a plea.
McCarrick. McCarrick Kirkwood. You need to see him, right?
I do.
I do.
Yes, absolutely.
Mr. Kirkwood, this lady needs to swear you in on some things so we can get this taken care of. Please see her. Thank you.
So please raise your right hand. You swear or affirm to tell the truth and the truth and nothing but the truth, self and God. Okay, get your right thumb front. Okay, place it flat right there. Okay, you can get up one more time. Right there. Here's your hand up.
And we now call cause number 25 CR 714, the state of Texas. Is it McCarrick? Is that okay? McCarrick Kirkwood, present with Ms. Nowdy, his attorney and the state's attorney. Does the defendant waive a formal reading of this indictment charging him with the third-degree felony of deadly conduct? And can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about May 5th, 2025, in Jefferson County, Texas, you committed the third-degree felony of deadly conduct by discharging a firearm in the direction of a habitation. Do you understand what you were charged with here, sir?
Yes, sir.
This is a third-degree felony if convicted, which means you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range that's applicable?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. You do well, and it gets closed out early in a third of the time. Another case, 25 CR 1289 will be dismissed. What is that?
It's a misdemeanor on the.
Oh, okay.
Weapon, Judge.
And then you've got this Glock 19 that was involved here. This is going to be forfeited as part of this agreement to the state. Is that your understanding of the agreement?
Yes,
And it
sir.
was a $500 fine also on this deferred or unadjudicated probation. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead in this case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Yes.
Yes, sir.
I'll show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct. State's Exhibit 1 tendered into evidence
objection.
without objection, it's admitted. Among other things, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You voted. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. John West is on the YouTube and his tie is showing. This is, do you understand all of this to be true and correct, sir? In State's Exhibit 1. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, Judge.
All right. If nothing further, I'm going to follow this agreement. McCarrick, anything you want to add? All right. If nothing further, I'm going to find you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation. This will be up to 10 years in length. You will be fined $500. You do well, it will be shortened. There's a Glock 19 that is described in this plea agreement. That will be forfeited. I guess that was recovered from you during an arrest or search of some kind. Also, there's another case pending 25 CR 1289. That case will be dismissed as part of this agreement. Anything else we missed? You're going to see the probation officer here in just a moment. He will go over all these terms and conditions of probation. Do well. It's in your best interest. You become a better person. And this gets shortened. You don't get a conviction. If you fail, your case could be revoked. You could be found guilty then and sentenced up to 10 years in prison. And then that comes with all kinds of problems. This alleges that you discharged a firearm at or in the direction of a habitation. The use of a firearm in the commission of an offense, if convicted, will affect your parole poorly. It has a negative effect on it. You understand? So move on with your life and do better. Okay. All right. Please see that nice man. We'll see you. Thank you. Do well. Yes, sir.